You own 4 rental properties. A tenant in property number 1 has friends over. One of the friends steps on a nail they said was sticking out of the stairs. They get a lawyer and a bunch of doctors who are saying, hey, that foot got infected from that nail, and all sorts of problems are surfacing now. They sue you for millions of dollars. Maybe the case is defensible, maybe it's not. Maybe your insurance company settles it, but let's make the facts worse. The tenant wins a judgment that exceeds your insurance coverage. Can the creditor reach properties 2, 3, and 4? Can they reach the equity in your home, your brokerage account, and your savings? If you own everything in your personal name, the answer may be yes. And if you put all 4 properties here in an LLC, you may have created a different version of the same problem. One lawsuit involving one property could easily expose every other asset sitting inside that LLC. If it sounds far-fetched, it's not. I had a client go through almost this exact scenario, but they were already structured the way I'm going to show you today, and they walked away without losing any properties or other assets. Today I'm going to show you the same basic structure my client used to walk away unscathed and what anyone can do to eliminate and mitigate risk for their rental properties. Here are the steps. First, we isolate dangerous assets. Next, we consolidate control of those assets. Then, we add protection against creditors who come after you personally, something called outside risk. And finally, we add privacy, because the less somebody can easily discover about you, the less attractive you'll look as a target. It's called security through obscurity, and it works. My name is Toby Mathis. I'm a tax attorney, an avid real estate investor, and a founding partner at Anderson Business Advisors. For more than 2 decades, my team and I have helped real estate investors structure and protect their properties. We've seen what works. More importantly, we have seen what happens when investors wait until after something goes wrong. So let's begin with the 2 most common mistakes. Mistake number 1, owning everything personally. The property is titled in your individual name, the lease is everything's in your individual name. The tenant writes the check to you. The county recorder tells the entire world, hey, this is everything that you own. You can see it all. And then when there's a lawsuit arising from a property, you are going to be a great defendant. You're an obvious defendant. You are attracting the lawsuit. Now, your insurance is still the first line of defense. I want to be clear about that. An LLC is not a replacement for a good liability insurance policy. But if the claim exceeds that policy limit, or the insured denies coverage, or there's a lower limit for whatever that is, or there's an exception to the policy, and there are a ton, you do not want the plaintiff staring directly at everything that you own. Mistake number 2, putting every property into one LLC. This is the one I see quite often with investors. And this is the investor who says, hey, I have an LLC, so I'm protected. Then I look at the structure and I see a bunch of rental properties sitting in the same entity. There's 4 properties here. That's not 4 protected properties. That is one bucket holding all of those properties. If a tenant on property 1 has a valid claim against the LLC, the assets owned by that LLC are available to satisfy the judgment. So that includes all of these properties. We have 4 properties in an LLC. You can get the equity from 1, 2, 3, and 4. Cash flow from 1, 2, 3, and 4. You did not separate the risk. You simply gave the entire portfolio a new name. And I call that the pile of assets. Everything's piled into a box. One lawsuit gets access to the box. Everything is still gone in one lawsuit. So how do we improve it? Step number 1, separate the dangerous assets. When a property has meaningful equity or meaningful liability exposure, we generally consider placing it into a separate LLC. A claim arising from property 1 is directed at the entity that owns property 1. So if we put each property in a separate LLC, something happens here, it stays in property 1. Property 4 is sitting way out here in another. Now, this does not make lawsuits disappear. It does not defeat a legitimate claimant against that property. It just narrows what they can recover against to that box. And it does not eliminate the need for insurance, because that's what's paying for the legal fees, the attorneys. What it does by doing this is it creates legal separation between the various types of assets, including your personal assets. What you are doing is you are attempting to contain the damage rather than allowing one claim to spread across the entire portfolio. Now, there are circumstances where you may put more than one property in an LLC. Maybe you have 40 or 50 properties, or maybe you have properties that have very little equity and you have a ton of properties and you just say, you know what, I'm okay putting 4 properties per box because I have so many boxes. But when you're just getting started out, no, it's really, we want to have each property separated out. There's other times where maybe the administrative costs of these is higher than the value of the properties that's justified. Is the juice worth the squeeze? And you say, you know, in my state, I'm paying so much money every year for the LLC. Let me try some other things like some equity stripping. I'm going to use the privacy, which we'll talk about later. There's some things that I'll do, but I don't want to have a ton of LLCs. So this is not about creating the maximum number of LLCs possible. It's about matching the structure to the equity and risk. But as a general principle, you do not want one high-risk asset exposing a group of unrelated assets. So let me ask you a question, and I'm going to ask you to put this down in the comments. How many rental properties do you currently own, and how are they titled? Put the number of properties in the comments and then write one of 3 things. Is it in your personal name? Then write personal. If it's all in one LLC, then just type one LLC. If it's more than one LLC or it's in some sort of structure, just write structure. So the number of properties and one of those words, personal, one LLC, or structure. If you already have that structure like this, you're just going to write structure. If they're all in one LLC, you're going to write in one LLC. This will tell me what type of scenarios I'm dealing with when I look at this, and what, kind of a informal poll. So let us kind of see just how bad it is, because I meet people every day. I talk to investors every day, and I'm always kind of shocked that so few people have actually heard about properly structuring it. Now, step number 2, and this is called a holding company. A lot of people, they own their LLCs individually. Not necessarily a good idea for the reasons I'm going to go into. But once the properties are divided up into these separate LLCs, you can add a holding company that owns those LLCs. And this holding company is going to more than likely be a Wyoming LLC. I'll get into that. So the holding company owns the membership interest in these LLCs. You own the holding company. Each property remains in its own little box, its own liability box, but ownership and control are consolidated at the holding company level. My strong preference in many situations is to use a Wyoming LLC. You say, why Wyoming? I've heard about that, but why? My accountant, he looked at me and said, well, you don't need to do Wyoming. My attorney said, why do? Here's the reason. Because Wyoming has favorable asset protection laws. It's cheap, has very low administrative costs. It's like less than $100 a year. And Wyoming has strong charging order provisions. It's the exclusive remedy. If somebody's coming after your entity, a Wyoming entity, charging order is the exclusive remedy. I'll get into why it is. The holding company also helps with administrative control. So instead of you personally owning 1, 2, 3, 4 LLCs, which may be, in many cases, the accountants love to set these things up to be partnerships so that you're doing a tax return for each. So you personally have 4 tax returns, 4 companies that are pointing straight to you. Instead of that, you own only 1. And we can even make it to where this has no extra tax returns. Although quite often, we're going to make this one what's called a 1065, which is a partnership return. There's a reason to do that for lending and some other reasons, but I'm going to save that for a different video. But what we do is we have it held here. Now, that is much cleaner and easier to use. You only have one tax return instead of 4, because these guys are going to be disregarded entities that flow directly onto the return without having to file a separate tax return of the holding LLC. The holding LLC makes it easier to manage the ownership chain, coordinate banking, bookkeeping, because we can have one set of books and then classes. If you know how QuickBooks works, you wouldn't have to have 4 sets of books. You would have one set of books with classes, which is so much easier and less expensive from a bookkeeping standpoint. And you keep your individual name away from these operating entities. Your name's not going to be on them. Now we get to the other side of asset protection, the one that nobody pays attention to, and it's called outside liability. Now there are 2 directions threats can come from. One is inside liability. Hey, I had again, tenant's friend step on a nail, and that's creating liability, and it's getting isolated. Tenant falls, contractor is working on property and slips and falls and is injured. The balcony collapses, you have fire, you have mold, God forbid. The per property LLC is designed to contain that type of risk. That's inside liability. The second type of threat is from here. And you're saying, but that's a smiley face. How could it create liability? That is a creditor coming after you for something unrelated to the rental properties. You cause a serious car accident. You sign a personal guarantee. Or you have some other creditor that's a personal creditor and they're coming after you. And now if that creditor has a judgment against you personally, they're going to start looking at what you own. You do not own the individual LLCs anymore. Your holding company does. Your personal asset is the ownership interest in the holding company only. And Wyoming law limits judgment creditors to a charging order as the creditor's exclusive remedy against that LLC. In practical terms, a charging order gives the creditor a right to distribution. So if you start paying money, the creditor, hey, I want the money you're distributing. Begs the question, why would you distribute money if somebody would take it? But that's why these things are so powerful. Think of this charging order, the maximum thing they can get is like a lien with no teeth. There's no management rights that come along with it. They can't force you to do anything. They just hope that someday you distribute profits to them. It does not automatically hand the creditor direct ownership in every property underneath it. They just have a lien against the distributions from the holding company. And what that does practically is it gives you substantial negotiating leverage. I control whether or not that creditor ever gets paid anything. Even if I lose a massive lawsuit, I'm still in control. But I want to be careful here. Charging order protection isn't like a force field. State laws vary on these LLCs. Wyoming just happens to be really strong. There's a difference between single member and multi-member LLCs in many states, so it may be treated differently depending on where you set it up. But in Wyoming, the same protections for a multi-member LLC are given to a single member LLC by statute. So it's about as strong as you get. Now, if you go bankrupt, bankruptcy court's going to get a hold of that, and that can create complications. There's something like, hey, I have personal guarantees, I have alter ego conduct, I have fraudulent conveyance, or I just don't maintain. I set it up with the state, but I never did any paperwork, I don't have an operating agreement. All those things can weaken this, but the statute is clear. So I want to just be really direct about here. The real principle is not that Wyoming makes you untouchable. If anybody's selling you that, it's just not true. The principle is it makes it really legally difficult for a personal creditor of yours to take control of your investment entities. It makes it really hard. And Wyoming is arguably the best state for this, especially when we consider step number 4. Step number 4 is privacy. I want to add privacy into the mix because it's arguably the secret sauce. Asset protection and privacy are related, but they're not quite the same thing. An LLC creates liability separation, legal separation. But adding a land trust, for example, to hold title, which a land trust is a title holding vehicle for real estate, where it can take your personal name off of that property, out of the county land records, and make it extremely painful for a creditor to even figure out who owns that property. They don't even see the LLC. A properly structured Wyoming holding company reduces the amount of ownership information that is visible in a public state record as well, because if you use like someone like Anderson to form it, your name's nowhere associated with this, or this, or this, or this, or this. And if it's not trust, guess what? Your name is not in the public records. When used together, the land trust LLC combo can make it next to impossible for a lawyer, there's a snoop, ex-spouse, angry tenant, you name it, to connect you to the properties you control. And why does that matter anyway? Well, because lawsuits are economic decisions. Those guys that are on the billboards, all those billboard lawyers, they're contingency fee attorneys. They only get paid if they collect. So they're going to want to know three things. If somebody walks in their office and says, I stepped on a nail, they're going to say, is there liability? Can we prove some damages? And is there a collectible defendant? If they see little to no equity in an entity, which is a land trust, if you do this right, they're going to say, I don't even know what the heck that is. We don't know who the beneficiary is. We're going to have to sue, and then we're going to see who the beneficiary is. And if they see a land trust, they know there's an asset protection attorney behind this thing. They're going to say, I don't even know if I can collect. So you can't prevent someone from suing you merely by keeping your name out of a database. But there's no reason to make it easy for them to see that you own a whole bunch of stuff that then they say, I want that guy. Reality check. Have you ever heard of a homeless guy getting sued? Why not? Because he has nothing to take. So I'm not saying you want to look homeless. I'm just saying you don't want to advertise your wealth and make it easy for somebody to see what you own in the public record. A simple structure where each rental is titled in a land trust with a separate LLC as the beneficiary, which in turn is owned by this anonymous LLC in Wyoming, and you have one of the ultimate protections. You have security through obscurity. People cannot tie you to all those properties. An internet sleuth, that tough guy that sits in his basement who's always trying to harass or call people out, that person can't see what you own anymore. They can't find it out. But privacy is not enough. You still need the legal protections of those LLCs. You still need insurance. I always think of it as kind of like a moat and walls. You want a moat around your stuff, but you still want the walls, and you want to have somebody that pays for the defense of those walls. You just don't want to rely on them solely. You want it to work together. So you add the privacy layer, and you have a very robust and effective plan that does not bust the bank. This is economically inexpensive to put together, but it's also one of the best protection plans that you can put together. Personally, I think that one of the best asset protection plans out there is the one that simply does not put up a flashing sign telling everyone where your valuables are located or what you own. Now, word to the wise. Do not mix safe assets and dangerous assets. I still have my brokerage account sitting out here, right? I'm going to put that in a box. What I will not do is put a bunch of cash in one of these. You don't want to have cash sitting in 1, 2, 3, and 4. You keep safe assets like stocks, bonds, or cash away from those dangerous assets. Just owning a rental property is a dangerous asset because it creates liability. Just owning it creates liability because the tenants live there, their guests visit, the workers make repairs, things break on these, people get hurt sometimes. Well, guess what? Cash, stocks, marketable securities, bonds, they don't create that type of liability. If you have stocks and bonds, nobody's slipping on your stock slip and suing you, right? Just owning some shares in whatever it is you own, let's say Microsoft, doesn't get you sued. These are safer assets. Owning a rental property, and I could get somebody slips and falls on it, that could create liability. The same thing doesn't take place in that. So that's a non-risk asset. So do not place non-risk assets, valuable brokerage accounts, inside an entity that owns an apartment building or something full of tenants. Don't leave $500,000 of excess cash sitting inside an operating LLC that's doing business with a bunch of people. And do not put several valuable unrelated assets into one entity simply because you said, hey, this is convenient. I'll just put my brokerage account and my real estate all in the same entity. Convenience, that's not the goal. Containment is the goal. I want to make sure that those risky assets go into boxes and are contained. If something bad happens, I want it limited to just the equity in that property. That way I can settle this thing. Insurance is going to be great there. Safe assets stay out here. You mix them up, you just remove the incentive for somebody to settle. Now they have something to collect against. Now, here's a big, huge one. I'm going to put this in bold letters. You must build it before the claim. This is the most important asset protection rule. You build the structure while the skies are clear. If you're already being sued, if you receive a demand letter, or if you know someone that was, like somebody was injured, or you can reasonably expect that you're going to get sued because of something that occurred, transferring assets at that point may be challenged as avoidable or fraudulent transfer. There's actually laws on this, so you can't wait until a creditor is at your door and then start moving everything. Oh, I'm going to move it around. Courts aren't stupid. Asset protection is proactive planning. It's like insurance. You can't just say, hey, I had a fire, now I'm going to go get insurance, could you cover it? Got to have the insurance before the fire. It's not hiding assets from an existing creditor either. It's building the walls before the storm, not during it. Now here's the bottom line. If all of your properties are in your personal name, you do not have a meaningful legal separation between your real estate risk and your personal assets. They're all mixed up together. That's really, really bad. If all of your properties are in one LLC, you may have separated the high-risk assets, that part of your portfolio, from yourself, but you have not separated them from each other. One property, bad occurrence, all of them go if they're in a single LLC. A more developed structure should include separate LLCs for properties with meaningful equity or risk, a holding company that for those separate LLCs, so it's not you. We want that holding company to have charging order protection from outside creditors and privacy. We want land trust to hold titles to each property for privacy. You don't even see the LLCs at this point, by the way. And then carry adequate liability and umbrella insurance. Careful separation between dangerous assets and safe assets too. The exact design depends on the properties, the equity you have in each, what type of loans you have, are there due on sale clauses, things like that, what states they're in, the tax treatment that you want, who the owners are, and your personal risk profile. If you want to walk through your situation, you can request a complimentary consultation with my team, but make sure you bring your numbers, bring your stuff. The link is in the show notes, or even easier, just go into the comments and type consult, and we'll send you a link to schedule a time. And by the way, if you like this type of content, well, this is the type of planning we cover at our tax and asset protection workshops. We've been teaching these workshops for just under 30 years. Trusts, LLCs, corporations, taxes, estate planning, all in a free one-day online workshop. Usually we do them on Saturdays, almost every weekend. Register now, the link is in the show notes, or again, you could just type workshop in the comments and we'll send you the link directly. Now do me a favor before you go. Please like this video, subscribe to the channel if you like this type of content, and more importantly, share this with somebody who will benefit from it. And I'll see you in the next one.